This is Matt Smith. I am president of the Greater Pittsburgh Chamber of Commerce, and I am very pleased to welcome everyone to this webinar. We actually have upwards of 750 people on the line with us here today, so we appreciate your involvement and your interest. This is going to be the first in a series of webinars that we are rolling out. Our next one will be next week and will be focused on small business assistance that's available to our region and to our country. On behalf of the Allegheny Conference and our affiliated organizations, the Greater Pittsburgh Chamber of Commerce, the Pittsburgh Regional Alliance, and the Pennsylvania Economy League of Greater Pittsburgh, we would like to thank our sponsors, Peoples, Giant Eagle, Highmark, and UPMC Health Plan, for their generous support, which allows us to bring this conversation to you today. Throughout its 75-year history, the Allegheny Conference has been a regional convener and trusted source for critical and practical information. During this crisis, our role is no different. We intend to use all of our platforms, web, social media, email, webinars like this, to bring the community and the region together and connect you to resources that will help us all move forward, united together as a region. Today, in our first webinar, we're bringing you information on recent changes to unemployment compensation, paid sick and medical leave, and other workplace changes. We're first going to hear from Aaron McLaughlin, a shareholder in the Employment Labor Practice Group at Buchanan, Ingersoll and Rooney. And then we'll hear from Jim Urban, a partner in the Jones Day Employment Labor Practice Group. After our legal experts' presentations, we'll open the floor to your questions, and my colleague at the Pittsburgh Chamber, Larry Hailsham, will moderate that dialogue. You may submit your questions at any time by clicking at the bottom of your screen. We will then compile the questions and answer as many of those questions as we can following our panelists' presentation. Thank you again for participating and for your interest, and let me now hand it over to Aaron McLaughlin.
Thanks, Matt. First, let me just say thank you to the Allegheny Conference, who is presenting what I believe to be an incredibly timely and an incredibly important topic to the public at large, because I do think that there are a lot of questions out there on what the Families First Coronavirus Response Act means to them and their business. I don't need to tell anyone this, but schools, and you can go to the next slide. Go to my first slide. Thank you. And next, perfect. Schools, restaurants, theaters, retail stores, law firms, and many other establishments are closed right now due to certain orders issued by our governor. And this is not specific to our location, but rather is an issue that is occurring nationwide. The result of these closings, the business slowdowns, is that there are millions that are going to be laid off if they haven't been already, really threatening the economy as a whole. And I think Jim's going to talk a little bit about the impact on unemployment. Just a few notes on the Families First Coronavirus Response Act. It was passed last week in response to a growing health and economic crisis caused by the COVID-19 outbreak. Specifically, what we're going to talk about today in my portion of the presentation has to do with provisions for paid sick leave and COVID-19 FMLA leave. If you could go to the next slide. As I said, this was passed last week. It was signed into law. It requires, among other things, paid sick leave and paid FMLA leave. And yeah, I did say paid. I think that is something that was somewhat unexpected and that we're going to get into because it raises a lot of question, given that FMLA leave, as we know it, is generally unpaid. The effective time period for these paid sick leave provisions and the FMLA provision as added by this act is April 1st of 2020 to December 31st of 2020. And I will talk more specifically as to how those effective dates and the date of termination will impact the different provisions. If you could go to the next slide. Next. Let's first talk generally about who is covered, because I think that is also surprising to many folks. I keep telling all of my clients, employers who have fewer than 500 employees are subject to the paid sick leave and COVID-19 FMLA provisions of the Fcra, and they keep thinking that they heard me wrong. Yes, so it's employers who have fewer than 500 employees are subject to the provisions. It also includes employers who are typically not subject to FMLA, so employers who have fewer than 50 employees. In short, what that means is for very large employers, if you are an employer who has 500 or more employees, you will not be subject to the paid sick leave and the FMLA provision under the FFCRA. So how do we determine who is covered? To determine whether or not you have the 500 employee threshold, you're going to take a look at all active employees, employees on leave, temporary employees who are jointly employed by you and another employer. For example, employees provided to you by staffing companies may be included. Now, the one caveat there is you need to be careful. So if you take the position for other purposes that that you are separate employers, you will want to be consistent here, or you run the risk in the future of being seen as a joint employer. If you move to the next slide, this is consistent with the FMLA provisions, but generally separate companies are going to be treated as separate employers unless they are unless their operations are sufficiently integrated to be considered a single employer. We see this a lot with health plans. The test to determine whether or not separate entities can be integrated for the purposes of determining that 500 employee threshold is the integrated employer test, and that is under the traditional FMLA. The factors that they look at in determining whether or not you are a sufficiently integrated employer is whether or not you have common management, the interrelation between your operations, are there centralized control of labor relations, and the degree of common ownership and financial control. Not one of those factors is determinative, but they will all be considered collectively. The same caution that I provided in terms of counting employees of joint employers as your own really goes here as well. And I say that because if generally you take the position that you are not a single enterprise, but rather are separate entities, you will want to really consider whether or not you want to run the risk of being viewed as a single enterprise moving forward once we get past this coronavirus outbreak. Next slide, please. Are there any exemptions? Yes, but they are, in my view, very limited. So there are certain exemptions for employers that employ healthcare providers or emergency responders. To get these definitions, we needed to look back at the traditional FMLA provisions, and I have tried to summarize who will be included as a healthcare provider. It really comes down to whether or not the person is authorized to diagnose and treat physical or mental conditions. Some notable exclusions or absences is probably a better word. For example, nurses, licensed practical nurses, CNAs, other potential caregivers who do not diagnose or treat physical or mental conditions. So unless we get further guidance from the Department of Labor expanding that definition, I do believe that we are going to be limited to the definition of healthcare providers as interpreted under the traditional FMLA. The question we've been getting or receiving a lot is, I don't have 50 employees, this is going to provide a financial hardship to me. You can apply for an exemption if you have fewer than 50 employees. However, you have to be able to show that your viability as a continuing business would be jeopardized by compliance with this new law. If you can show that, you're going to have to apply to the Department of Labor to get an exemption. It will have to be approved by the Department of Labor, and you will be deemed not to have to comply. What about my collective bargaining agreement? So if you are a single employer that is party to a collective bargaining agreement with a union, you still are required to comply, as is any other employer. If you are subject to a multi-employer collective bargaining agreement, you may be able to work with your union, negotiate with your union for coverage provisions within your collective bargaining arrangement. However, it's a may, so the union is not required to do this, and to the extent you are not able to negotiate some sort of arrangement, you're still going to be required to provide the leave. You can go to the next slide. So in sum, as to whether or not you are a covered employer, the key takeaways here, I would say, are if you have fewer than 500 employees, you will be subject to the paid sick leave provision and the COVID FMLA provision. The next sections are going to talk about what that means. So if you are subject to the paid sick leave provision, how much paid sick leave are you going to be required to provide? Full-time employees under the new paid sick leave provision will be entitled to take up to 80 hours of paid sick leave under the Fcra, and that's for certain qualifying circumstances, which we're going to talk about. Your part-time employees are also eligible and entitled to take paid sick leave. They will be entitled to the average number of hours they typically work in a 2-week period. So for example, if you have somebody who works 20 hours a week, they're going to get 40 hours of paid sick leave under the new law. That paid sick leave is going to be immediately available. So this, as I said earlier, this law goes into effect on April 1st, that the paid sick leave entitlement will be available for immediate use on April 1st for your employees. So when can an employee use paid sick leave? There are 6 identified circumstances in which an employee will be entitled to use their paid sick leave. The first, if the employee is subject to a federal, state, or local quarantine or isolation order related to COVID-19. I will tell you, this is probably the one I've received the most questions on. The question that has arisen is, for example, the shelter-in-place order that we're currently under, whether or not that is the employee being subject to federal, state, or local quarantine or isolation order under this provision. The short answer is, based on the definitions of quarantine and isolation, as those terms are used by the CDC and the WHO, our position right now is that this provision is not triggered. Do I think that it is somewhat ambiguous in nature and that my interpretation is subject to challenge? I do. I think creative plaintiffs' lawyers and employees could argue that a shelter-in-place order is essentially an isolation order or a quarantine, and try to make the argument for employees being entitled to paid sick leave because they're off due to the current governor's directives. However, my view of this is more when, for example, the government quarantines an individual and puts them into isolation, rather than, you need to stay home, you need to shelter in place. The second category is whether or not if an employee is advised by a healthcare provider to self-quarantine. So this is the situation in which your employee experienced symptoms. They went to a doctor. The doctor either diagnosed them as a presumed positive, or in fact they were tested and confirmed to be positive, and were directed to self-quarantine for the 14-day period. They would be covered in category number 2. The third category is the category I find most nebulous, and that is if you have an employee who is experiencing symptoms associated with COVID-19 and is seeking a medical diagnosis. The symptoms we've often heard associated with COVID-19 include coughing, a fever, things often associated with a common cold and a flu. The challenge here is I do believe that if you have an employee who's experiencing any of those symptoms and is seeking medical treatment, they will be entitled to take paid sick leave under this provision. The fourth category is really anybody who is caring. So if you have an employee who is caring for an individual who falls within subparagraphs here 1 and 2. The fifth is an employee who is not able to come to work because they need to be home to care for a son or daughter who is home from school or whose place of care is closed due to COVID-19 precautions. The sixth is a more of a catch-all, and I think it's if the employee is experiencing any other substantially similar conditions specified by the Secretary of Health and Human Services in consultation with the Secretary of the Treasury and the Secretary of Labor, that's going to have to be defined by those secretaries, and they will have to provide further guidance on those points. To the next slide, how much do I have to pay an employee on leave? So the first 3 categories I generally look at as the employee being provided leave due to a circumstance that applies to them. So for the first 3 categories, that's the employee is subject to a quarantine or isolation order, the employee has been advised to self-quarantine, or the employee is experiencing symptoms. Employers will be required to pay employees required compensation. That's generally the regular rate of compensation for the paid sick leave up to $511 a day. There's also an aggregate cap on that of $5,110. To the next slide. For employees who take paid sick time to really care for another under the circumstances identified in the paid sick time law, they will be entitled to 2/3 of their required compensation, up to $200 per day, and an aggregate cap of $2,000 per employee. So to the extent you have an employee who needs to be home to care for example, a son or daughter who is home from school due to school closure or place of care closure, they will be entitled to up to $200 a day in compensation. To the next slide. So some of the questions that we've already received, I've tried to outline here, but what if I already provide PTO? As drafted, I think the paid sick leave provision is in addition to whatever paid time off an employer is already providing to an employee under their policy or under another statute. The exhaustion of other leave. Employers are not going to be able to require that employees use up their accrued but unused PTO prior to using paid sick leave. That paid sick leave will be available to the employee to use immediately as of April 1st. Employers cannot require that the employee find a replacement before they're permitted to take the leave. That's the employer's obligation. There is a provision for an employer to require notice, but it's only that they can follow reasonable notice procedures after they've already been notified on the first day that the employee has a need to take paid sick leave under the provision. What happens to paid sick leave upon termination of employment? We're getting this question a lot. Do we have to pay it out? No. So employers are not required to pay accrued but unused paid sick leave under the provision. And to the extent employees have accrued unused paid sick time in their allotment, so for example, from their 80 hours for a full-time employee, it will not carry over past December 31st of 2020. There are restrictions in terms of not being able to frankly discriminate against an employee who takes paid sick leave or files a complaint for failure to provide that sick leave. It's pretty typical to your other standard discrimination provisions. So you can't fire somebody, you can't discipline somebody, you can't treat them disparately based on the fact that they're using their paid sick leave entitlement or that they filed a complaint. There are penalties, the penalties associated with failing to provide the paid sick leave as required under the Fcra are basically the FLSA penalties for failing to pay minimum wages. And in addition to that, there are going to be penalties for willful violations. Moving now from paid sick leave, it dovetails right into the COVID-19 FMLA leave under the Fcra. I will tell you the biggest complaint that we are hearing on this is that employers who have never been subject to the FMLA before now have an FMLA obligation. So who is eligible for COVID-19 FMLA leave? Different from regular FMLA leave that requires you to be employed for 12 months and to have worked 1,250 hours in the prior 12 months. All employees who have been employed by the employer for 30 calendar days are going to be eligible to take COVID-19 FMLA leave. If we go to the next slide, it's when can an employee use COVID-19 FMLA leave? It's actually a very limited circumstance. Employees will be permitted to use COVID-19 FMLA leave if they have a need or if they are unable to work or telework due to a need for leave to care for his or her son or daughter under the age of 18, if that child's school or place of care has been closed. The question I have, and one that has not yet been resolved, is who makes the decision as to whether the employee is unable to work or telework, and specifically as it relates to telework. I have 2 small children, and I can tell you there are days that I feel like I'm unable to telework because they're here. So if the employee is able to make a decision as to whether or not they are able to telework, they could opt for leave instead. How much COVID-19 FMLA leave are eligible employees entitled to? As with the traditional FMLA, employees are entitled to take up to 12 weeks of COVID-19 FMLA leave. So they are entitled to up to 12 weeks to the extent they need to be home with a son or daughter whose place of care or school is closed due to COVID-19. This leave entitlement begins on April 1st. We've received a lot of questions about employees who may have been using FMLA leave for other reasons prior to April 1st and whether or not that'll count against their FMLA entitlement in terms of COVID-19 FMLA leave. The way I read the provision is the entitlement begins on April 1st. So employees will have 12 weeks from April 1st to take their COVID-19 FMLA leave to the extent the circumstance requires it. Is COVID-19 FMLA leave really paid? Yes, and I put an exclamation point on there. Now, the first 2 weeks, as documented in the statute, is supposed to be unpaid. However, as a practical matter, the first 2 weeks are either going to be paid under an employer's policy if the employee elects to use PTO or other accrued time, or under the paid sick leave provision that we discussed earlier in this portion. The remaining 10 weeks of COVID-19 FMLA leave will be paid at the same rate of pay that the paid sick leave was paid at for caring for another person, which will be 2/3 the employee's regular rate for the number of hours that the employee would otherwise be normally scheduled to work, with the paid leave capped at $200 a day. So in short, for that remaining 10 weeks, if an employee needs to be off work to care for a son or daughter whose place of care or school is closed due to COVID-19, they are going to be entitled to pay at 2/3 of their regular rate of pay per day, up to $200 per day, and $10,000 as an aggregated cap. So what are the key takeaways here? What are my obligations under the FFCRA if I furlough employees or temporarily close my business? This is what I referenced earlier. The position that we're taking in the interpretation that we currently have is that if an employer makes a decision to close or cancel work shifts due to business reasons, lack of work, neither paid sick leave nor COVID-19 FMLA leave will apply because essentially there's no work being scheduled, the employee is not scheduled, there is no reason for them to take leave, protected leave, to excuse them from a regularly scheduled shift. That said, the employee is still eligible for that time. So once the employer begins to schedule employees for work, they will then be entitled to use that leave to the extent the circumstances arise. What are my next steps? We are encouraging employers to develop policies and or addenda to their existing policies to account for the paid leave, paid sick leave and COVID-19 FMLA leave provisions. We are supplementing, providing a temporary supplement to FMLA policies. The other thing we're doing is developing forms so that employees who are requesting such leave can document the reasons for the request, and employers can have a record of it. Employers also have a posting obligation in terms of employee rights under these new provisions. Yesterday, the Department of Labor published the notice that will be required to be posted on site at the employer's place of business, and I have placed a copy here, and there is a link to the DOL site on the previous slide. I'll now turn it over back to Matt to introduce Jim. Thanks.
Thank you, Erin, and we'll turn it over to Jim at this point. Again, Jim is a partner with the Labor and Employment Group at Jones Day. So Jim, without further ado.
So good afternoon, everyone. This is Jim Urban, partner at Jones Day here in Pittsburgh. Can we skip to the second slide, please? And go on to the next one, please. So we want to talk first about what the issues are that employers are facing. And of course, first and foremost is, given the unforeseen business circumstances, what is a viable plan forward? What we're hearing is employers foremost want to help their employees. Of course, the other issues are, at this point in time when there's no revenue coming in or it's coming in very slowly, you want to minimize cash outlay by the business, and you also want to minimize the administrative burden at a time when resources are stretched. Skip to the next slide, please. So we are asking the people who we provide advice to be very precise about how they're approaching it. And people throw around the term furloughed, they throw around the term laid off. And truth be told, you can have someone who would be characterized as having been laid off, but at the end of the day, they're really terminated from employment with no expectation of recall. So that scenario might be, say, a plant closing that an employer engages in where there's no expectation that the plant will reopen. The employees who work there are severed from the payroll. There's no expectation that they will return to the payroll. When you terminate an employee, that triggers a number of obligations, which we're going to walk through here today. And that's a scenario that, in this circumstance, we want to avoid. And so what we're advising most employers to do is look at what we are describing as being a temporary furlough, which could also be referred to as a layoff. So employees who are furloughed, they remain employed. So they're still on your payroll, albeit inactive, not working any hours, not earning any wages. They continue to receive group benefits such as health, vision, and dental until they are recalled to active work. When they return, it is without the administrative burden of having to re-onboard them, rehire them, whatever term you want to call that. Skip to the next slide, please. Now, if you're imprecise with your language or you are effectuating what is a termination of employment, we perceive that category to be employees who were severed from the payroll. They ceased to be employed. while perhaps being deemed to be eligible for rehire later, they actually become former employees, at least for the short term. They cease to be eligible to participate in your group benefit plans, except perhaps via COBRA continuation. We think that's a less favorable scenario in the present circumstances. Skip to the next slide, please. So I want to talk first about why the furlough path is a viable alternative here. So when you are temporarily furloughing employees, you're telling them, just as I said a few minutes ago, you are still on our payroll, you are an inactive employee, you are not going to be working any hours, you're not going to be receiving any wages. The consequences of that path are you're probably not going to have WARN Act obligations. So there's a federal statute, the Federal WARN Act, that requires employers who engage in a mass layoff to give 60 days notice to their employees. Because this would be a temporary layoff not expected to exceed 6 months, it would not trigger WARN Act obligations. Also, because this is a temporary furlough for the short term with expectation of recall, if you have a severance plan, you're unlikely to trigger any severance plan obligations unless, honestly, there's a hole in your severance plan language. Most severance plans trigger an obligation by the employer to pay benefits if someone loses their job through no fault of their own, without an expectation of recall. Of course, here, we all have an expectation that we're going to recall our employees once the public health crisis is behind us. If you are characterizing it as a temporary furlough with expectation of recall, you may have collective bargaining obligations. Most CBAs have language, furlough language. It may trigger an obligation to perhaps, say, subsidize unemployment. So you need to know what your CBA says. If you have employees who are subject to employment agreements, so these would probably be higher level employees, and you are furloughing them, that could trigger your obligations under such agreements, so you need to know what those say. For instance, a material diminution of duties or a material diminution of salary under most employment agreements can trigger an obligation by the employer to make a payout. So if you have those types of employees, you need to know what their employment agreement says. Paid time off. If you were in the Commonwealth of Pennsylvania terminating an employee, you would probably have an obligation under the Wage Payment and Collection Law to perhaps pay them paid time off if that was your practice with respect to any other termination. Some employers, when an employee leaves the payroll, their practice is to pay for accrued but unused vacation. So in this circumstance, as we render people inactive, if that somehow would be classified as a termination of employment instead of a temporary furlough, you might have an obligation to pay out the paid time off that they haven't used. Of course, that's a cash outlay, which is one of the scenarios that we're trying to avoid. Welfare benefit plan eligibility. One of the things we're hearing from most employers is that they really want to work with their employees to keep them eligible under the group benefit plans. So most group benefit plans address this circumstance. They will allow an employee who hasn't worked any hours for a period of time, say 30 to 60 days, to remain eligible, at which time afterward they may become ineligible and suffer a COBRA event. I can tell you that some states are taking action. Ohio is an example. The insurance department in Ohio issued a directive within the past week that said third-party insurers, so these are third parties that provide group health plans to employers, they are not permitted to enforce work eligibility provisions, such as having to be active at work or minimum hours worked. They're not allowed to disqualify plan participants if their hours fall below the threshold or if they go a period of time without performing any active work. What you can do with the welfare benefit plans is look at your plan, see what it says. It's probably going to allow you some period of time to keep furloughed employees as plan participants. Some employers are offering to actually pick up the employee's share of the premium during the period of furlough, and then they would recover that once the employees return to active work several months down the line. It would just be an increased monthly contribution. It benefits the employee because it keeps it pre-tax as opposing to have the employees on furlough cutting a check and mailing it in. So that's something to think about. And then, of course, because you are keeping these people on your benefit plans through a period of furlough, you're probably not going to have any COBRA notice or COBRA administration issues. The Families First issues were just covered by Aaron. And of course, the other thing about a temporary furlough is it eliminates the administrative burden of having to rehire and onboard folks who would come back to the payroll later if you actually terminated them. The great thing about the furlough path, getting to the $64,000 question here, is, well, how does it impact their unemployment compensation eligibility? And it's probably not going to impact that, which I'll cover in detail in a few minutes. Can we skip to the next slide, please? Now, if you're not careful with your language, if you are just making the overt decision that you're going to actually sever people from the payroll, the consequences of that are going to be as follows. You're likely going to have some WARN Act obligations because it is an employment loss covered by the WARN Act as long as you meet the other triggers. You potentially could have severance plan obligations because employees may be able to make the case that they are severed from the payroll without an expectation of rehire, or at least significant question as to whether they are going to be subject to rehire. You are very likely going to have collective bargaining obligations that can run a number of ways. There may be termination pay that is bargained for and due and payable to union represented employees. You're probably not going to have control over who gets furloughed, or I'm sorry, who gets terminated, because it's going to probably be by inverse order of seniority. And then recall rights will probably also be triggered too. If you are terminating employees, you are definitely going to have employment agreement obligations, because for the more senior management employees who have such employment agreements, the ability to actually terminate employment may be limited to for-cause scenarios unless there's a force majeure clause. You absolutely, if you terminate employees, are going to have paid time off obligations in states where you're obligated to pay accrued but unused paid time off at dismissal. That's a cash outlay. If you terminate the employment of individuals, it's likely going to immediately impact their welfare benefit plan eligibility, because most of your plans are going to have eligibility criteria that require the employee to actually be an employee to participate. That, of course, hits the next bullet point, which is an obligation to give COBRA notice and then administer, after the notice is given, benefits to those who choose to continue them pursuant to COBRA. I'll skip over the Families First because Aaron covered that. And then if you're going to rehire these people 3, 4, 5 months down the road, once hopefully the public health crisis is behind us, you likely are going to have more administrative burden tied to rehiring and onboarding. Under this scenario too, they're going to be eligible for unemployment. Let's skip to the next slide. So the thing about unemployment is it's generally viewed as being state controlled. What a lot of people don't know, and what they're learning this week, is that it's a joint state-federal program. And the states administer it, but it's largely driven by guidelines that are established by the feds. So the federal agency that does this is the Employment and Training Administration, which is within the U.S. Department of Labor. Last week, or I guess by this point it was 2 weeks ago, the DOL issued guidance to the states. Clearly it saw coming what was coming and put the states on notice that the states should be interpreting the criteria for unemployment eligibility, so eligible to receive benefits. That criteria should be interpreted in a fashion that renders eligible people who are temporarily furloughed as a result of circumstances tied to the virus. Can we skip to the next slide, please? So the DOL guidance basically said this, is that federal law permits significant flexibility to the states to either interpret or amend their laws to provide benefits in multiple scenarios related to the virus. And here's some examples. Employer temporarily ceases operations due to the virus preventing employees from coming to work. We've seen that all over Pennsylvania this week. Individual is quarantined with an expectation of returning to work after the quarantine is over. Of course, we've seen those scenarios too. Or employees are leaving voluntarily due to a risk of exposure or infection or to care for a family member. So it's broad interpretation, liberal interpretation of the eligibility criteria so that people can be rendered eligible and receive benefits. Can we skip to the next slide? In Pennsylvania, the Unemployment Compensation Bureau is telling folks that you can be eligible for benefits if you fit any of these scenarios. None of these are surprising. They fit right in with what we've heard all week long. This is right on the opening page of the UC Bureau's webpage when you go there. So I think you can anticipate that whether you are characterizing your employees as being temporarily furloughed with an expectation of recall in the short term, or whether you are actually severing the employment relationship, under each of those scenarios, folks are going to be deemed to be eligible for benefits. Can we skip to the next slide? Okay, that was it. I need to cover a couple more things, though. One of the issues that has popped up is in Pennsylvania, employers can participate in the UC coverage program one of two ways. So one is the contributory method, where that's where employers pay contributions, commonly known as a tax, based on a contribution rate and a taxable wage base. So contributory employers, they're eligible to request relief from UC benefits paid to claimants that are charged to the account. You should know that if you are a contributory method employer, the state has made known that it will be granting relief to such employers, and also such employers will not likely have a heightened tax rate that is assessed upon them for unemployment. So that's the good news. But the other side of it is there's a second set of employers who do what we call self-insuring for purposes of unemployment compensation. They are known as employers who participate in the reimbursable method. And employers who elect to do this, if they qualify, they basically reimburse the unemployment compensation fund for the amount of benefits charged to their account and are billed dollar for dollar on either a quarterly or a monthly basis. So in this present scenario, I mean, that can be a huge, huge hit for an employer who has his business closed because of the present circumstances, has furloughed temporarily most or all of the workforce, and now can expect to be hit with this dollar for dollar reimbursement demand from the state. It is an open question at this point whether relief will be granted to such employers, but I'm actually going to be on a call at 1:30 with some legislative leaders here in Pennsylvania to discuss this precise issue. And what we are proposing that be considered is that there be an amendment to the statute as it exists. It currently provides the state the ability to grant all employers relief from unemployment compensation obligations in the event of a disaster that closes the business and then causes people to be laid off. The definition of disaster is somewhat narrow, and under a plain language reading of it might not cover the scenario presented. So what we're asking legislators to look at the issue and if possible, consider an immediate amendment to the statute that would broaden this exception and allow employers to receive relief from charges due to unforeseen business circumstances caused by a public health crisis, pandemic, however you want to phrase it. Our thinking is it should be a no-brainer, largely because the money that's going to fund the unemployment benefits is coming from the feds as part of the huge stimulus package that is going to be passed. So that's kind of a stay tuned issue. The good news is that regardless of how you proceed, temporary furlough or termination, most of your employees are probably going to be rendered eligible for benefits. I would urge you, though, as you are considering how you characterize your action, consider the consequences of it with respect to other issues that we talked about here today. Welfare benefits eligibility for your employees. Are you triggering a WARN Act obligation? Are you triggering a collective bargaining agreement obligation? Are you triggering severance plan obligations? You should be looking at this big picture and pursuing the path that best fits your needs, minimizing cash outlay, minimizing administrative burden, equipping your business to sustain the crisis while helping your employees as best you can. So Matt, that's about all I have to cover. I'll throw it back to you.
Thank you, Jim, and I'll turn it over to my colleague Larry Hailsham with the Pittsburgh Chamber.
Thanks, Matt. We're going to move into the Q&A portion of our webinar. Thank you to all that have submitted questions prior to. Our first question comes from Ann. Ann is curious about whether or not employees need letters on letterheads saying that they are an essential employee, so that as they need to travel to and from their facility, if they're stopped, maybe this letter could be used as collateral to verify that they are an essential employee, and if the employer is listed on the essential business list. Just trying to get some clarification on that.
I can take that one, Aaron, if that's all right.
Yeah, that sounds great.
My view at this point is you don't need to do that. There is not a strict order that says everyone must be in their home. The order, as handed down by the governor, provides for certain businesses to be able to remain open. I think that law enforcement recognizes that those businesses are remaining open with permission and that people are going to need to travel to and from them. And I'm not aware of any law enforcement just randomly pulling people over and asking them why they're on the road. So my view is, at this point, circumstances could change, but at this point, I don't think that's necessary.
Thank you. Our next question comes from Bethany. Bethany's question states that they have decided to continue to pay employees that are full-time and part-time hours for being at their organization, even if they're closed and they're not working. They're paying their servers and bartenders who normally receive a service charge rate. In addition to their below minimum wage flat rate, they're getting dollars above the minimum wage. So of the employees' claim, they would receive more money if on unemployment. So the question is, if they refuse the payment and we stop paying them, are they eligible for unemployment? What are the risks to us as the employer in allowing this to happen?
Okay, that's a lot to digest. So let me see. You want to offer to continue to pay employees even though they're not working, and they may refuse the pay because they think they can make more just going on unemployment. Well, a couple moving parts to that. First of all, everyone needs to be aware of ultimately what the stimulus legislation tomorrow, the vote's going to be tomorrow in the House, how that ultimately becomes law. I heard a characterization on a call yesterday that for some folks, for a lot of folks, this could turn out to be the longest paid vacation in the history of the United States. Whether that's true or not, that remains to be seen. But I can tell you most employers are looking at the question of what can we do to help our employees. Ultimately, though, is it better for us to just allow them to avail themselves of the benefits that will be available, as opposed to us putting the cash layout ourselves? That's an analysis that every employer needs to make on their own. It's a financial calculation that takes into account a couple things. First, what are we capable of paying them? Second, what are they eligible to receive on their own? And then third, if we pay them something, how is that going to reduce or offset what they might be able to get in the form of unemployment compensation benefits? I've seen this week by employers a number of spreadsheets that make those calculations very easy, and I would urge all employers out there who are looking at these issues to consider doing the same thing. You should not be doing a cash outlay if you're putting the employee in the same spot they might be just availing themselves of government benefits.
Thanks, Jim. Our next question comes from Gary, and Gary's question states, are there any changes to unemployment compensation eligibility for past earnings requirements due to COVID-19? Example he raised was the base period, highest earning quarter, total wages, etc.
I can tell you that I am not aware of any changes to the base period calculation, but I'll qualify that by saying, this will be driven down from the feds. You need to wait and see, the devil's in the details here, what the statute ultimately says. As we sit here on this call, the text of the legislation itself is still being drafted. So that's a little bit of an open question, but I've not heard of any changes to the base period look back.
Thanks, Jim. Our next question is for Aaron, and it's from Sharon. The federal unemployment compensation aid states that it will pay an additional $600 weekly to unemployment compensation filers on top of what the state is paying. And they're just seeking clarification that that's correct.
Is that question for me or is that question for Jim? Is it related to the unemployment?
Yeah, it's unemployment. I'll take that. Look, so all we know at this point is what Schumer put in his letter, his dear colleague's letter. And what he wrote was that the agreement that was struck between the Republicans and the Democrats increases the maximum unemployment benefit by $600 per week and ensures that laid off workers on average will receive their full pay for 4 months. Key words in that sentence are on average, okay? So you need to wait and see what the formulas are going to be, and because I think what you make is going to impact, or what your base period earnings were might impact what you ultimately get. If it's, I believe the maximum weekly rate in Pennsylvania is 400 and change, so if it turns out to be $600, you could have people who are now going to get $1,000 a week in unemployment benefits. Remains to be seen.
We're receiving a lot of questions about whether or not slides are going to be available at the end of our casting. We're going to make the webinar available online. Our next question comes from Deanne, and their question is about whether or not FFCRA is going to apply to nonprofits.
The answer to that question is yes, it will apply to nonprofits so long as you fall within the fewer than 500 employee definition.
Okay. And then our next question comes from Chris, and it's whether or not does paid leave under FFCRA have to be used consecutively, or is it treated like intermittent leave?
I have seen nothing that requires it to be used consecutively. The only way it's been phrased is you have an hour entitlement. So for full-time employees, it'll be 80 hours, and nothing in the provision leads me to believe that there will be a requirement that 80 hours has to be taken together.
Our next question comes from Joe. And his question states that we are furloughing a large percentage of our workforce next week. Many have expressed a desire to continue working during their unpaid time off. Are they permitted to do so?
No. If employees are performing work, they need to be paid for their work. If they are a salaried exempt employee, generally speaking, they'll need to get their full salary for that work week. If they are an hourly employee, they will be, you will be required to pay them for whatever time they work at their regular rate.
Some employers are telling their furloughed employees that you are not permitted to perform work while you are on furlough. And that if you do, you're going to be paid for the work that you do, but you'll also be potentially subject to counseling or discipline for not adhering to the requirement.
It's a good point. You know, that Jim states, the problem is it's a wage and hour issue. So to the extent employees are performing work, they absolutely have to be paid.
It's a good question. Our next question comes from Pia, and the question states, what would be the process for applying for an exemption? For an example they gave was for financial hardship for a small business.
As I understand it, there is no specific procedure laid out in the current law. It's possible we'll receive additional guidance on that, but as I understand it, you would have to apply for the exemption with the Federal Department of Labor, specifically the Secretary.
Our next question comes from Elizabeth. Their question is, if someone is working remotely at home, but they also have infants and toddlers at home, which is limiting their work, would they qualify for assistance under this act, or do they have to be actually on leave?
So I think the question is, if an employee is working at home and they are being less efficient than they typically would be in the office due to children at home, they should be, even if they're being less efficient, if they're working, they're not going to be on leave. So the leave provisions wouldn't be triggered. The next question would be, if I'm an employee who is able to work remotely but have to care for my children, can I take the paid sick leave? And I believe the answer to that would be yes. If you need the leave to be able to care for your children who are at home, then you're going to be entitled to take that leave.
Our next question comes from Myrna. Can employees receive full unemployment benefits if hours are reduced to only 5 or 6 hours a week?
This is Jim. I'll take that one. I can't do the math for you, but you can receive benefits if you are partially unemployed, or I should say underemployed, if you're actually underemployed. So if your hours are reduced, it's going to depend on what you're making, working those reduced hours, and how that fits into the state's formula. It's a fairly straightforward formula, and it's numbers driven. So I would take the hourly rates. You're going to have to look at the base period, and you'll be able to determine whether or not that person will be able to collect. I can tell you, employers who thought they would pursue a scenario of having someone work reduced hours ultimately abandoned it because they didn't think it was worth the employee's benefit. Employers were trying to find scenarios where individuals could actually work some hours, collect underemployment benefits, and basically have them make as much as they possibly could, but sometimes that doesn't always work out. It's formula driven.
Okay. Our next question comes from Brandis, and the question is, if employees are furloughed, do they continue to accrue PTO while they are furloughed?
We have been telling employers that that's their own judgment call. Sometimes, you know, what I would first do is look at your own policy. So if your own policy says you accrue PTO based upon hours worked or based upon weeks worked, I would apply your policy. And so if someone's working 0 hours and not working any days, not working any weeks, then they would not be accruing under your policy. Now, you can always amend your policy. If you're in a state like California, where, there's a gazillion crazy laws on the books, we are telling employers in California or who have operations in California, in order to avoid, as a result of a temporary furlough, having to pay accrued but unused paid time off at the time of the temporary furlough, to allow the employees to continue to accrue during the furlough. California is an outlier. Other states, it probably is not necessary. But you start with your own policy, you apply your policy. Some companies, if you're employed there, you start your calendar year with a bank of so many days, and you don't accrue it during the course of the year. If that's your policy, that's your policy. But look at your own policy and apply it, I think, is the best advice. Erin may have something to add there.
No, my advice is consistent with what Jim said. I agree wholeheartedly.
Thank you. Our next question comes from Paul, and it's related to FFCRA benefits. And the question is there a need to provide, for employees to provide proof from a doctor or child care provider to support their eligibility for FFCRA benefits?
It's a great question. As currently drafted, there's no requirement that an employee provide proof, and the CDC and the WHO have come out and asked employers not to require such proof because the doctors are already overloaded given the current crisis. So my answer to this is yes, you can provide, you can require, I would say, certain confirmation. I think of a child some confirmation that the child is under 18, some confirmation that the child's school or place of care is closed, but frankly, the documentation you're going to get is not going to be verifiable. So I don't know if I would even bother.
Okay. We've received several questions sort of around the clarification for when the start date for the unemployment changes is going to be effective.
That remains to be seen. As far as the enhanced money, the extra $600 per week on average, is that what the question is?
Yep.
I would assume that is going to be immediately. We'll see when the final bill gets signed into law after the House vote tomorrow. But I should have added earlier, I'll add now. Two things Pennsylvania specific. Pennsylvania typically had a waiting week. That has been eliminated. So anyone who has a COVID-19 scenario applies for benefits. You're not going to have to wait a week before you start receiving them. The second thing is, typically when you're on unemployment, you have an obligation to seek alternative work, and that has been suspended in this scenario. So some here, I expect the heightened benefits amount to be available immediately, and then combined with what I just said, there's not going to be a week of waiting, so this should move pretty quickly.
Okay. Our next question comes from Curtis. If you have more than 500 employees, but you elect to comply with FFCRA anyway, do you still qualify for the tax reimbursement?
As currently drafted, I think the answer to that is no.
I would agree.
Okay. Carol's question is, can you require staff to perform work at home during FFCRA?
No. If the employee is taking leave, they should be relieved of duties. If they are working from home, they should be paid as if they are working from home, so performing work.
And here's the rub with that. So you have two categories of employees. You have your non-exempt hourlies and your exempt salary, right? So your non-exempt hourlies, if they are performing work at home, you owe them pay for all time worked. So if they worked 20 hours, you owe them 20 hours at their hourly rate. The salaried exempts, you know, the FLSA contemplates that those folks are paid a set amount regardless of whether they work 20 hours in a week or 80 hours in a week. So they're not eligible for overtime, but if they work 20, they still get their salary. You don't want to be having salaried exempt people be performing 10 hours of work at home because you're going to create FLSA issues for yourself.
Okay. Our next question comes from James, and it's a question around email access. So if an employee is temporarily furloughed, do they need to maintain email access? And I think this question sort of comes from if you want to email them to let them know, when they're coming back or additional information about their furlough, do you need to maintain their company email? Or do they need to maintain access to that email?
Well, here's the risk. If you have employees who are furloughed, sitting at home, and they are running through their work emails, making sure they are staying on top of things, responding to vendors, responding to customers, and you know they're doing it, and you haven't told them not to do it, you're putting yourself at risk for an off-the-clock work claim when this whole thing gets wrapped up. As we look, into the crystal ball and try to predict what the wage and hour plaintiffs' lawyers are going to seize upon, that might be specifically one thing that they seize upon. If you have work-related apps that are on people's phones, if your work email is on their phones, if they can access it via their computer from home, it's potentially a risk. Is it a risk that warrants cutting them off? That's a decision every employer has to make. What you should do is have a policy in place that says to your furloughed employees, when you are furloughed, we don't expect you to be performing any work. You should not be reviewing your company email as a matter of course. You shouldn't be responding to customers and vendors. You shouldn't be communicating with other employees about work matters, things of that nature. So at least if you get a claim down the line, you can say you had a policy as opposed to having no policy at all.
Our next question comes from Anne. And if an employee has a medical issue, for example, high blood pressure, and it's worsened by anxiety of COVID-19, would they be eligible for paid FMLA COVID-19 related leave if this occurs before April 1st?
Okay, can you read that again? Sorry.
Yeah, no, it's okay. So if an employee has a medical issue, high blood pressure, and it's worsened by anxiety of the COVID-19 crisis, would they be eligible for paid FMLA leave if this occurs before April 1st?
So no, the answer to that is no, they wouldn't be entitled to paid FMLA leave because the provision for paid FMLA leave only applies to the circumstance in which an individual is home caring for a child who is home from school or whose place of care is closed. So the second question that would arise is whether or not they are going to be eligible for the paid sick leave provision. And that one's pretty attenuated. My initial reaction is no, unless their healthcare provider would direct that they isolate on that basis. And Jim, I would certainly, welcome any input that you have. But my initial reaction to that, as those facts are provided, is no, not under the paid sick leave law. However, remember that you still have all of your obligations under the Americans with Disabilities Act. So to the extent there is an obligation to engage in the interactive process, you still have those obligations right now.
And so did that question have something about April 1st in it too?
It did.
What was the April 1st element of the question?
The question, that element was if it happens before April 1st.
So nobody's eligible for benefits until April 1st is I guess, kind of one aspect of this. But when April 1st rolls around, then assuming they can satisfy the other eligibility criteria, the benefits are available to them as of that day. So if they're asking for it today, it doesn't exist. Aaron, am I right?
That is correct.
Okay. Our next question comes from Joe. Construction companies with fewer than 500 employees are not considered to be small businesses if they do more than $40 million in revenue. Do those standards apply in this situation?
They do not. The only eligibility requirement is that if you have fewer than 500 employees, you are subject.
Okay. Allison's question states, once the shelter-in-place order is lifted and social gatherings in places like dine-in, restaurants, bars, nightclubs, events happens, what's the process for quickly onboarding our laid-off employees?
Well, I think that's something everybody needs to be thinking about right now. And your process is going to be not all that different from maybe someone who's coming back from FMLA leave. So if you need to conduct certain trainings to reacclimate people, perhaps safety training, that's something you need to consider. If you have cut off access, obviously you're going to have to, when I say access, I mean electronic access. You got to restore all that. But I think that the onboarding or the recall process will be unique from one employer to the next. But honestly, everybody needs to be thinking about that right now to figure out how things can get back to normal as quickly as possible. So you're talking about facility access, electronic access, training that may be necessary. You know, it runs the gamut. If you haven't terminated them from your payroll, which is, I think, the course we're recommending to most employers for the reasons I articulated earlier, then it's just a matter of recalling them. It's not like you have to make them come forth with 2 forms of ID to demonstrate their eligibility for work. They never left your payroll in the first place. So it's not like a rehire process.
Our next question comes from Mary. If a company is reducing schedules due to lack of work, can exempt employee salaries be reduced without their losing of their exempt status?
I can take that one. So keep in mind, again, 2 buckets, and we're advising employers to recognize what the 2 buckets are and treat them distinctly. So the hourly non-exempts, you are not going to mess with their hourly rate, most likely. And if you're reducing them, you're reducing their hours worked, and then you're paying them for all time worked. Now, on the salaried exempt side, you can reduce their salary. Many employers are reducing salaries. You need to be aware of what the minimum salary is in order to maintain the exemption. So the federal exemption limit or minimum is $35,000 and change. There are certain states, however, that have higher thresholds. California, it's $54,080 annually. So you need to be looking at what the FLSA threshold is for the exemption. But if you are in a particular state that has its own wage and hour law, minimum wage law, you need to be looking at what it is in your state. It might defer to the FLSA minimum, or it could be higher. And you generally do not want to go below. We are advising against dipping below. It's probably not a risk worth taking.
Our next question comes from Dana. Should employees working from home be reimbursed for supplies, printer cartridges, paper, etc.?
I can go ahead, Aaron.
You got Tim. We have taken the approach that they should not, that those are basic supplies now. What I will say is, to the extent employers are requiring that their employees purchase those items, and they would fall below minimum wage, I think there could be a wage and hour issue there. But generally speaking, we have been requiring employees to provide general office supplies in working at home. Jim, I don't know what your thoughts there are.
Yeah, I would tend to agree. I mean, circumstances will differ from one to the next. You have to get done what you need to get done with your folks who are working remotely from home. And there might be unique circumstances that require a unique approach. You know, generally though, you don't need to reimburse them for things that they should have at home in the first place.
Okay. Our next question comes from Mark, and it's really just around whether or not you know anything about when the Department of Labor is going to publish any guidance related to FFCRA.
Well, that's the $1 million question, Mark. And, you know, they provided guidance, I want to say a day or two ago, and the only substantive takeaway that I had from it really was that they changed the effective date from what we all presumed was going to be April 2nd to April 1st. We understand that there may be guidance, but as to when that guidance might come out, we don't know. And certainly as to the scope in terms of substantive materials, we haven't heard anything on that front either.
I posed that question to someone who formerly was in the Trump administration, and the view expressed back to me was there likely will be emergency rulemaking that occurs, and you know, that could come out Sunday. Who knows?
Okay. Jeff asks a question that's related to the effective date of leave. So their company has had employees that have been sort of on leave before April 1st. And his question is whether or not FFCRA will be applied prospectively after after April 1st of 2020, or retroactively to apply to those employees who are already on leave due to COVID-19 reasons. And I think you sort of answered it, but I think that Jeff's question merits a little bit more attention.
Sure. So if I understand the question, it is whether or not the provisions will be retroactive to attach back. The answer to that, as I read it, is no, that the provision of 80 hours of paid sick leave and the provision of COVID-19 FMLA leave will be prospective from April 1.
And I would add to that, again, the question was posed with the word leave. Employees are on leave. Be precise with your language. So what I assume the questioner meant was employees have been temporarily furloughed with an expectation of recall. So they're still your employees, but they are not working, not earning any wages. That being the case, if you furloughed them before April 1st and the regs regarding FMLA do not change, which they could if we see emergency rulemaking, but if the regs do not change, there is an existing FMLA reg that says if you are currently on layoff, while on layoff and before you get recalled, you are not eligible to avail yourselves of FMLA leave. So under the existing reg, if you're already furloughed, you probably cannot avail yourself of the expanded FMLA leave. Again, rulemaking could happen between now and next Tuesday. This could change, but that's one view.
One of our questions comes from Mary, and the question is related to whether or not S-Corp owner employees are eligible for unemployment compensation.
So these are folks who are self-employed, I assume, and I think the answer will be no, but that could change.
Okay. Brett has a question, and it's how does the Pittsburgh Paid Sick Time Act going into effect on March 15 interact with this sort of new, this new situation we're in.
As I understand it, any leave that would be provided under the paid sick time law, the leave required to be provided under the new federal provision will be in addition to policies governing paid sick time.
Okay. We've got a number of questions and it looks like we are running a little short on time. We'll be sure to see if we can get answers to folks' questions at a later point, but this concludes the Q&A portion of our webinar. Thank you so much. As I mentioned, we will have access to this available after our presentation. And for now, I'll hand it back over to Matt.
Thank you, Larry. And I want to note our particular appreciation for our speakers, Aaron McLaughlin, as well as Jim Urban. Thank you very much for your assistance here. This has been very informative. We appreciate you bringing your expertise to bear on what is a very fast-moving legal and talent management issue that we're all grappling with at the same time and in real time. So we look forward to continuing to engage with each of you on these issues. The Allegheny Conference, I wanted to note, launched a website last week. And as Larry said, this webinar will be on the website. We hope that the website serves as a resource for all of you and is an important repository of important resources, legislative updates, and ways that each of you and your organizations can help the community. The website is www.alleghenyconference.org/COVID-19. Again, that's www.alleghenyconference.org/COVID-19. I also want to give one more note of appreciation to our sponsors, People's, Giant Eagle, Highmark, and UPMC Health Plan for their generous support, which allows us to bring this conversation to you today. Please be on the lookout for an invitation in the next couple of days to join us next week for a webinar on small business support. Much of today's discussion, a lot of today's discussion related to the Phase 3 legislation that is moving through Congress and is, both Jim and Aaron noted, is expected to be voted on via a voice vote tomorrow in the U.S. House of Representatives. We expect that legislation to emerge from the House and be on the President's desk at some point tomorrow. So that will then be in effect, and that's obviously going to involve many, many questions, many issues that come up, particularly in the small business context, and how each of you and your organizations and your employees can access that information and the funding that's available as part of the Phase 3 process that Congress is working through right now. So please be on the lookout for that webinar. It should come out in the next day or two, and it will be held next week. And will include, similar as today, experts who can provide practical and concrete information to each of you as you manage this issue and manage the situation so we come out on the other side stronger and better as a region. So thank you all. Be well, stay safe, and take care. And thank you for participating in today's webinar.